Hey out there, legal warriors. What I get a lot of questions about in my office regarding restraining orders is, hey, whatever's written in that restraining order, if it talks about a crime, does that go to the police? Am I being prosecuted for a crime based upon what's in a restraining order? In the next video, I'm going to cover the answer to that question and one more very important question regarding restraining orders, police, and criminal liability. So if you're interested in that area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington state for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. Now I'm just going to jump right into it. A restraining order is actually legal term in Washington state is protection order, and it's under RCW 7.105. And the legislature changed the law back in summer of 2022 to make it so easy for anyone to get a restraining order against someone else. And so there's hundreds and thousands of these each week that courts have to deal with. And therefore, I get a lot of questions. A restraining order is when someone claims something against the respondent that entitles them, in their opinion, to have an order saying the respondent can't do certain things. And those claims are in a petition. And the petition usually says things, bad things about the respondent. And oftentimes it's accusing the respondent of crimes. Think about a husband-wife situation, boyfriend-girlfriend. They're saying, hey, the respondent hit me or pushed me or broke my phone. All these or threatened me. All these different types of things that, if reported to the police, would be a crime if it was believed by the police. So the question that we get in our office quite frequently is what's in that restraining order claims by the petitioner, are the police going to come get me, right? Are they going to charge me with a crime just based upon what is in the claims of the petitioner in the petition I just got served with, Lance? And the answer to that question is it depends, of course, but usually no. What I want you to know as the viewer of this video, and if you're a respondent, is that whatever the petitioner writes in the petition does not get sent to the police, at least not by the court. The court has no role in initiating criminal charges against people, right? The court is the one who decides certain things about criminal charges, but they don't start criminal charges. It's the prosecuting attorney or the police department that start criminal charges. So a restraining order is not the government versus the respondent. It's the petitioner, somebody's name, against the respondent, someone else's name. It's not State of Washington versus defendant X. It's petitioner versus respondent X. And for that reason, the petition typically is only going to make it to the court file, and the court is going to deal with it. If the court sees a whole bunch of claims about assault or sex assault or things like that, if it hasn't already gotten to the police, the court's role is not to send those documents to the police. Now, it still may get to the police because the petitioner may also report the allegations to the police, or the petitioner's attorney, if he or she has one, may find it's to their advantage to report these allegations to the police. But just because it's in the petition does not mean that the police knows about it, or they get a copy of the petition, or you're going to get charged with a crime because of what's in the petition. So that covers the situation where we're talking about a respondent who's received a petition with bad claims against them that would be a crime if they were true. And if there's been no report to the police already, just because this petition is filed in the court, it is not forwarded to the police department or the prosecutor to use against you. So remember, I said I was going to cover a second thing. Let's say we're a respondent and we've received a petition against us, and it alleges crimes that we've supposedly done that would justify an order to the petitioner, right? They hit me, they punched me, there was a sex assault, they stole something, who knows what. In that case, I want you to read the petition closely and see, is there evidence that they've already reported this to the police? So many times we're going to see a police report box checked, the police report is attached, or we'll actually see a case number that the petitioner will reference. And that case number is easily identifiable by the year. Like if it's a 2024 case, it will probably say 24 dash something. If it's a 2023 case, 23 dash something, or sometimes there's no dash, just 23 number. Now that's a dead giveaway that the police are involved in this situation. And in any case, but especially in that case, if you're the respondent, and remember, we're supposed to respond to these petitions in writing with our side of things prior to the permanent order hearing date. If we're the respondent, we have to be very careful about what we write on our response, right? If it says that the respondent slapped the petitioner in the face, you don't want to say, well, I didn't slap the petitioner, I only shoved the petitioner. Because, I didn't slap him. Well, a shove is still a crime. And so if you're writing something in there that is admitting to criminal activity and there's already a police report that exists, now it's fair to believe that if a prosecutor gets a hold of that case to charge and they're doing their job, they may look up your record, they'll see that civil filing against you, and then they may obtain a copy of your written response. And your written response is typically sworn under oath, and they're going to be able to use that against you in proving their criminal case. Even if it doesn't mention a police report, we still don't want to admit to criminal activity in a response. These are reasons why you need attorneys. These are reasons why an attorney may tell you as a respondent not to even respond and instead try to negotiate a case if we can, because a restraining order is a civil matter. It is not a crime. It does not go on your criminal record. If we violate the restraining order, it does go on our criminal record, but a civil order typically expires for the most part in 1 year. And it's not some huge mark on your record because people have to dig to see what it is, right? It's just going to say respondent. It could be a divorce. It could be some type of civil action against you for money, all types of things. It's not going to end up as part of a criminal conviction history because, again, it's civil. It does not involve the government versus you. It's a person versus you. So what do we want to take away from this? If there's bad things that look like crimes in a petition against us, it does not necessarily go to the police. But in any case, if we're responding to what's written there, we need to contact an attorney. We need to know what's actually a crime or not. We need to realize that even breaking our own phone in a marriage, that's community property. It's your phone, you use it, but it's half your spouse's also. So you have to educate yourself because what you write in that response can and will be used against you if it happens to get to law enforcement or a prosecutor. Usually it doesn't. It doesn't happen automatically, but it can, especially if the other side is smart and they're trying to use every advantage they can get in doing you harm. So I hope this has helped. I hope you're not in this situation, but if you are, the most important thing is reach out to an attorney. If you have a restraining order situation, you can give my office a call. We've been doing this for more than 20 years. We get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.